To make you the smartest person in the room, we have to talk about the notion of standing. As you know, in many Second Amendment cases, government defendants try to argue that Second Amendment plaintiffs lack standing to knock their cases out. Well, guess what, folks? Two can play at that game, and I'm going to show you how we can use the doctrine of standing to shut down this attempt by states to thwart Donald Trump's executive order on birthright citizenship. Let's get into this right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the winner of the 2025 Top Voice of the Second Amendment in America at the 2025 Gun News Awards out there in Las Vegas. Thank you for your support. I could not have done it without the support of the followers and subscribers to this channel. So thank you for standing by us and fighting for this channel and for our right to keep and bear arms. All right, folks, so we have to talk about the concept of standing. Remember, I've explained to you before, to make the smartest person in the room when it comes to defending our Second Amendment rights, as well as all of our constitutional rights, you need to understand not just the substance of the law, which means what is the law, how does it apply, how do you win with it, which is what we often talk about when we talk about the Heller and Bruin tests and the like. But there's something that's equally important that we sometimes talk about, and that is the process or the procedure whereby you womb to tomb, a lawsuit or a criminal case from the beginning to the end so you can vindicate our right to keep and bear arms. Now, I'm going to talk about the notion of standing in the context of how perhaps we in the Make America Great Again movement, if you will, the Donald Trump movement, the conservative movement, the originalist movement, whatever movement you want to call the conservative movement in America, which is trying to restore American constitutional law to a place it never should have left, which is what I think is really going on here. I don't think it's a radical revolution going on by conservatives in Washington or in the courts. I think what we're trying to see or trying to accomplish is a restoration of the law to a place it never should have left. So with that said, we've talked a lot about the concept of standing. There have been many instances, as you're well aware, where lawsuits have been brought seeking to vindicate the right to keep and bear arms. And courts have, in many instances, dismissed those cases, arguing that the plaintiffs failed to establish standing. Now, what is standing? Standing is basically the concept that says that if you're going to sue in a court, specifically in a federal court, you have to have standing. And why is that? Because if you read the U.S. Constitution, Article 3 of it, remember Article 1 of the Constitution deals with the Congress, Article 2 of the Constitution deals with the White House, the presidency, the executive branch, and Article 3 deals with the federal judiciary, including the U.S. Supreme Court. In Article 3, it specifically says that federal courts are only allowed to hear a case if it's a live, real case or controversy. And what that means is you have really actual parties that are fighting about a real issue where a court can remedy it or resolve the issue in some way using this court system. Now, one of the critical components of this that's essential is that the plaintiff that brings the lawsuit has to have standing. And what standing means is that that person has a real interest in the case, that there's something going on in the world today that is hurting him or her, or has hurt or will hurt him or her. They have a personal stake in the outcome of the case. Now, the classic example from our point of view is, let's say you want to take your handgun into the post office, right? But you're not allowed to because the law says you can't bring your gun into the post office, and you want to be able to go into the post office to defend yourself if you need to, but you can't bring your gun in. That's an example where you would argue that your personal right to keep and bear arms is being violated because you go into a post office, you're not allowed to bring your gun there, and that exposes you to dangers. So you are the one being hurt by that particular law. Likewise, let's say you live in Illinois or New Jersey or California, and you want to buy a particular kind of AR-15, let's say, with particular features, whatever it is, and the state says you cannot buy it because they've been banned. Again, another example where you have been actually hurt because something you want to buy, you are denied the ability to buy. So you yourself have been injured. It's a real controversy. You've been directly harmed, and the court can order the state not to enforce that law as to you, and therefore the state or the court has the ability to redress and fix that situation. That would be an example where you would have standing. Now, I want to talk about how to use standing offensively for a change, because remember, to make you the smartest person in the room about the Second Amendment, we sometimes have to talk about other legal strategies in other contexts, because you can learn a lot about how to fight cases and controversies in cases other than Second Amendment cases, and you can draw off what you learn in those other fights and bring it to bear to benefit the Second Amendment. And that's why I want to talk about some of my thoughts about the notion of standing when it comes to some of these states, you heard me right, states that are suing the Trump administration, claiming that Donald Trump's recent executive order that says that birthright citizenship, which is the notion that if you're born in the United States, that alone gives you U.S. citizen, that makes you a U.S. citizen automatically under the 14th Amendment. But again, I'm not going to belabor the substantive point in this particular video. We'll do that in a separate video. But as you know, the 14th Amendment to the U.S. Constitution, which was enacted after the Civil War, that was designed specifically to ensure that the African American slaves that were no longer slaves under the 13th Amendment, that they would be full-blown citizens. And the 14th Amendment to the U.S. Constitution was designed to do that. And there's two critical clauses that have to be satisfied for you to be a citizen here in the United States. Being born. The first is you have to be born in the United States. You have to be actually born in the United States. But there's a second part that in my view, the liberals, the progressives, the people that like illegal aliens always want to forget. And that is the language actually in the 14th Amendment that doesn't just say born in the United States, it also says subject to the jurisdiction thereof. Now, we're not going to talk about what subject to the jurisdiction thereof means in this video. We've talked about it in other videos. We'll do it in the future. But all I want to point out is that there's two criteria that must be met to be an American citizen. You got to be born in the United States, and you got to be subject to the jurisdiction thereof when you're born. That second part is the part that the liberals like to ignore, the progressives like to ignore and pretend that doesn't exist and has no meaning. That is not allowed. But again, that'll be a fight for another day and a subject of a separate video. What I want to talk about today is standing. Specifically, many states have now sued the Trump administration, claiming that the executive order dealing with birthright citizenship, where Donald Trump now says, no, if you're the kid of an illegal alien, you're not, and you're born in the United States, you are not an American citizen. That is crazy talk to think that some pregnant woman can either sneak in on a fraudulent visa that denies that she's pregnant and then has a baby here, and then her kid becomes an American citizen, at which point, through the family reunification laws, it serves as an anchor baby to drag the rest of the family in the United States. Or if some illegal alien comes into the United States and has a kid here, and guess what? Now the illegal alien can say, hey, I got to stay in America because my kid's an American citizen. You can't kick me out. So you see how this game gets played. It's this so-called anchor baby phenomenon. Now, nevertheless, whatever you want to argue about the merits, which we'll get to in a separate video, the reality is this. States have sued to challenge this law. But my question is, how is this possible? Because if you think about it, we've talked about what standing is, but how do states like the state of California have standing to sue, for example, over this issue? How have they been hurt? Well, the first thing I would say is the only people that really have standing, and listen carefully because you're going to see the strategy here really quick, and it's going to help you think through this issue in other Second Amendment cases, for example. How does a state have standing? Well, I don't think they do. The only person that directly has standing, as I see it, are whom? That would be the illegal aliens and the kid of the illegal alien, right? The just born child. They're the ones that are being hurt, if anyone, by this executive order. The state of California is saying we're being hurt because we're being denied federal monies for these people, but the reality is that the cost associated with welfare and all these other programs, including education, to raise these kids and take care of the illegal alien parents, that undeniably costs a heck of a lot of money, more so than anything they're going to get in from the federal government. And nevertheless, again, they wouldn't need the federal money to subsidize any of this, even in a theory, if they didn't have the illegal aliens in the first place. So the states are actually going to financially benefit if these illegal aliens and their kids are not in the state, because the state will save a lot of money. So the states don't seem to have standing because they're not actually being hurt. If anything, the Donald Trump executive order benefits them by saving them a ton of money. So there's no way the states have standing to sue. So who does? And again, it goes back to my point that the people that have standing to sue, as I see it, are the illegal alien parents and the kid or kids of the illegal aliens. So why is this important? You're like, Mark, why is this so important to standing? And how do we take advantage of this? And if you think about it, these are civil cases. Why does that matter? You have to sue. Someone has to sue in court. So let's just play this out. Let's say you have 3 illegal aliens suing as plaintiffs Donald Trump, and their kids are suing via the parents' consent, of course. Guess what? They're going to have to be named in that lawsuit. As soon as those 3 people are named in the lawsuit saying, I'm an illegal alien, I live here and I'm suing, and the next person says, I'm an illegal alien and I live here and I'm suing, and so on and so on and so on. It seems to me, as soon as those names are revealed to ICE, which is the Immigration and Custom Enforcement Agency, or the DHS, whatever you want to call it, whoever's involved, ATF, FBI, they're all now all getting involved. The reality is, once they're revealed, it seems to me that the federal government could go arrest these particular plaintiffs and deport them because they've already admitted, which is undeniably the case, if they've admitted this, that they're illegal aliens and not allowed to be in the United States. So every time they come up for air, every time they reveal themselves, yes, they will need to do that for standing, but nothing would prevent ICE or the federal government from at that point going out, finding them, arresting them, and deporting them because they know where they are. And again, there's no doubt that these are crimes under federal law. You're not allowed to break in America without our consent. So again, the people with standing, it seems to me, that would have standing to sue Donald Trump over this case are the same people that could easily be disclosed and deported in the event they revealed themselves. Now, the other thing is, as you know, often there are depositions. Now, what are depositions? If someone sues, the defendant has the right to take discovery, which means to get information about the basis of the plaintiff's lawsuit. So if these illegal aliens sue with their children, the defendants, meaning the government, can say, look, we want to take their deposition, right? We want to serve them. We want to have them come in for deposition so we can ask them questions to establish, among other things, that standing exists. And of course, when they show for the depositions, it seems to me that federal law enforcement would be able to, yes, indeed, arrest them on the spot and deport them at the same time. So this is kind of how I would do this. Now, they could argue that we want to remain anonymous. We want to sue to remain anonymous. That does sometimes occur when you're dealing with like minors, for example, sometimes in family court cases. But it seems to me it's not a particularly compelling argument. I don't even think it's a legal basis to say the following, that I am a criminal committing crimes in the United States and I don't want the federal government who I'm suing to know about me because then I will get arrested and deported. That doesn't seem to make a lot of sense, because put that concept into a separate concept, into a separate context, where let's say I'm a cocaine dealer or a illegal drug dealer or engaged in some other illegal activity, and I bring a lawsuit against the federal government to say, I am an illegal drug dealer. I am illegally doing all these crimes, and I don't want my name revealed because then I'll get arrested. But it doesn't seem to me that's going to be a lawful basis or a legal basis for a federal judge to say, yeah, Mark, you can hide your name and hide your identity in this context because, yeah, we don't want you to get arrested. I don't think courts, as a general matter, would accept that. But at the end of the day, even if I'm not publicly revealed, at some point I have to reveal myself to the federal government because they are entitled to discovery of me to ensure, for example, I have established standing, whereas the plaintiff, I bear the burden to show that I have standing in a case. And again, as we've just gone over, states don't have standing as I see it because, if anything, they are beneficiaries of the executive order by Donald Trump, and they don't get hurt because think about the money they're going to save if they don't have to actually take care of these kids on welfare and all the schooling and all the other social services they have to provide. So there's no standing there. So, and again, if the illegal aliens and the kids sue, well, guess what? You can deport them. So again, once you deport them, they're not going to be able to sue in the United States that easily because they're going to be in another country. So again, I wanted to talk about this sort of strategy and how to think about some of these things, because the more you think about how to litigate, how to conceive of issues, how to possibly react to things, how to benefit from certain laws, it helps you understand how to be a better legal thinker and attorney. And these are some of the thoughts I have about how Donald Trump's lawyers potentially could deal with these civil lawsuits challenging the executive order on birthright citizenship. And again, as you know, this is not a foreign concept in the Second Amendment concept, in the Second Amendment context, because again, the anti-gunners like to argue there's no standing in Second Amendment cases. So I say, fine, two can play at this game. We're going to argue there's no standing when the states and these other folks sue the federal government, but there is standing if the illegal aliens sue. And if they do sue, I don't think we need to tell Tom Homan what should be done in that instance. But again, I'll let you think it through, and maybe you guys have other great ideas that you can share with me in the comments below, which I do read. So there you have it, folks. Hope you learned a little bit something here today about the importance of process and procedure in these kinds of cases. And again, it's important to know the process and procedure as much as it is to understand the substantive law you're trying to vindicate. So there you have it. Make sure you follow me on X at 4boxadiner. Don't forget to follow me on Rumble and YouTube. Subscribe to both. We're trying to close in on 200,000 subscribers on YouTube. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.